Good evening and welcome. This is the October 26, 2022 public hearing of the Land Use Commission. The City Code directs this body to hear applications for map and text amendments, special uses including plan developments, zoning relief, and appeals from decisions of the zoning administrator, as well as to make recommendations regarding the city's long-term planning goals and objectives. Depending on the type of matter, the Commission will either make a final determination or send its recommendation to City Council. Ms. Ashbaugh, would you please call the roll?
Commissioner Aravallo is absent. Commissioner Cullen is absent. Commissioner Halleck.
Here.
Commissioner Hugo.
Here.
Commissioner Johnson. Here. Commissioner Lindwall.
Here.
Commissioner Miranchev.
Here.
Commissioner Pucktell.
Here.
Commissioner Westerberg. Chair Rogers.
Present. So with 8 members present, we do have a quorum. Also present tonight from city staff are Planner Katie Ashbaugh, Zoning Administrator Melissa Klotz, and Interim Community Development Director Sarah Flax. We also have Brian George representing the Assistant City Attorney Brian George representing the Law Department. This is a formal hearing and there are rules that govern our proceedings. Most importantly, only one person speaks at a time, so all testimony may be accurately recorded. Anyone who wishes to address the Commission on any matter on tonight's agenda will have the opportunity to do so at the appropriate time. Commissioners may ask questions at any time. Our procedure is to hear from staff on the documents on file and then receive testimony and other evidence from the applicant or appellant. After that, persons wishing to make a statement regarding the matter will have a chance to do so. Any person with a legal interest in property located within the defined notification requirements of the subject property may present evidence, reasonably question witnesses, or seek a continuance of the hearing. When all supporting and opposing testimony and statements have been heard, the applicant or appellant will be given the opportunity for rebuttal or a closing statement. Then the Commission will close the record and begin deliberations to consider the standards. The Commission will make formal findings of fact based on the testimony and evidence presented, guided by the standards and Commissioners' knowledge of the community and the recommendations of staff. All testimony is taken under oath. Although we do not apply the strict rules of evidence, please limit your testimony to the proposal as it relates to the standards contained in the zoning ordinance and the corresponding staff memorandum. When testifying, please state your name and address for the record and sign in on the public comment sheet. Our meetings are audio and video recorded. Please make sure that you are at a microphone when asking questions or making statements so that you can be properly recorded. All proceedings are subject to broadcast at a later date. Any matter not concluded at tonight's hearing will be continued to our next regularly scheduled meeting. We do have several items on the agenda this evening. I'm just going to take a roll call for who's here. Is the applicant for 2125 Madison Place present? Thank you. 3101 Central Street. Oops, I seem to have a wrong page. What's the next one?
It is major adjustment to a plan development for 1012 through 1016 Church, Northlight Theater.
Present. Okay, and the last one?
2012 Maple Avenue, an appeal.
And they are here as well. At this point, I'm going to ask that anybody who thinks they may speak to us on any matter on tonight's agenda be sworn. If you would please raise your right hand at this time. Do you swear or affirm to tell the truth throughout the course of these proceedings? Thank you. With that, we will enter into our agenda. The first item on the agenda is the minutes for the October 12th meeting. Has everyone had an opportunity to read those, and are there any edits? If there are none, is there a motion to approve?
Motion to approve the minutes.
Moved by Commissioner Lindwall. Is there a second? Second by Commissioner Halleck. Any further discussion? Hearing none. All those in favor, please say aye.
Aye.
Any opposed? Anybody who was not here? Commissioner Westerberg abstains because she was not present at that meeting. With that, we will move into the new business for tonight's hearing. The first matter on our agenda is 2125 Madison Place, 22 ZMJV 0081, and I will ask that that please be read into the record.
Theodore and Nicole Fancher, property owners, request a major variation from section 6-8-3-7A2 of the Evanston zoning code to allow a street side yard of 6 feet 6 inches where a street side yard of 15 feet is required for an addition to an existing single-family home in the R2 single-family residential district. The Land Use Commission is the determining body for this case in accordance with section 6-3-8-10 of the Evanston zoning code and ordinance 92-0-21.
Thank you. I don't, is it Fancher? Is that the correct pronunciation? Yes, please come up to the lectern and tell us about your project.
Hi, we're requesting,
If you could start, please, with your name and address for the record.
sure, Theodore and Nicole Fancher, 2125 Madison Place.
Thank you.
We're requesting a variation to our we're requesting a 6.5 feet setback on the west side of our home, following the existing setback. The proposed addition is approximately 6.8 feet in length. We're just looking to add more living space to our home addition, to add in additional space for our living room.
And it's following the existing line of
Of
the
our home.
home, which is currently set back 6.5 feet on that west side Hartree facing area of the living room.
Can you blow that up? Blow that up so that we can see the whole thing? Yeah. So the addition is the area in red, correct?
Yes.
And it's following the line there that's on on both sides of the property all the way back.
Right, so, and everything is in compliance except for that 6.85 foot
Feet.
Right.
setback, yeah.
Yeah.
Yep. Commissioners have questions? Okay.
I just had one observation, which is that the address is Madison, and yet the door is on Hartree.
So we're going to move our door to the right place.
Well, it doesn't really matter because
It
the zoning-
doesn't, no, I just, because we often ask, like, okay, where's the front door, where's how do you determine front yard, side yard, and all that, and I just thought it was interesting, but.
It confuses a lot of people.
Yeah.
And just a question, you're adding, the addition adds some space to the living room as well as the porch and then the new bedroom that comes out, is that correct?
Yes.
And it'll add an additional bathroom as well.
Right.
Any other comments or questions from commissioners? Hearing nothing else, I'll ask if there's anything you would like to say in summation. Obviously, we don't have a lot of questions, which, I mean, some cases are pretty straightforward.
I think we're okay.
Yeah, nothing to add.
So anything you'd like to say as we wrap up? Okay. Was there anybody else who showed up tonight to speak on this matter? All right. You may go ahead and sit down.
Thank you for your time.
Thank you. We will go ahead and close the record then and begin our deliberation. Based on the fact that there really weren't any questions, I think everyone's kind of in agreement that this is one of those cases where it's kind of a logical, makes sense situation since the side yard setback has already been infringed upon to follow that line with the new addition of the house. We do have 7 standards that we must find are met before we can grant any sort of a variance. We are the determining body on this particular matter. I will run through those 7 standards quickly. The first one being the requested variation will not have a substantial adverse impact on the use, enjoyment, or property values of adjoining properties. This is basically an addition that will continue a property line. We've heard nothing from any of the neighbors who have come to speak for or against this. Therefore, I believe that this standard has been met since no one has come to say that this will drastically affect them. The requested variation is in keeping with the intent of the zoning ordinance. This will allow an existing structure to remain and be improved, which is one of the things that our variations seek to do. So I believe that this standard is met. Number 3, the alleged hardship or practical difficulty is peculiar to the property. Often we find that the side yard setbacks in properties that are on street side yards often are already violated. And so this is the problem you have when you apply a code to existing properties that don't necessarily always conform. And it has always been the policy of the city through this body to allow people to make those improvements as necessary. And in this particular case, again, since the violation already occurs, continuing it will not have a drastic impact on the property, and it is unique to this particular property. Number 4, the property owner would suffer a particular hardship or practical difficulty as distinguished from a mere inconvenience if the strict letter of the regulations were to be carried out. Again, with these properties, if we enforce the full street side yard, we often find that houses become shotgun houses where one room is literally stacked behind the other. Again, since this already is a property where that 15-foot has been infringed upon, and we don't seem to have any issue with people complaining about the way that it's already been infringed upon, I believe that this standard is met. Number 5, the purpose of the variation is not based exclusively upon a desire to extract additional income from the property. We've heard no testimony from the applicant in this particular case that they intend to rent out any area here, that they intend to sell the property, or do anything that would generate additional income from them. It makes an existing house that is fairly small more usable for today's families. So that standard is met. Number 6, the alleged difficulty or hardship has not been created by any person having an interest in the property. The condition of this property has existed for some time. I did not ask the homeowners when they purchased the property, but based on how old I am guessing them to be, this condition existed long before they were probably born. So I would say that that standard is met. And number 7, the requested variation requires the least deviation from the applicable regulation among the feasible options identified before the before the Land Use Commission. And again, if we were to enforce the strict letter of the rules here, it would create less usable space for this particular home, and this is not an egregious addition that they are seeking, so I believe that standard is met. Is everyone in agreement with my findings on standards? With that, I will ask if, I don't think there's any conditions to place on this, so I'll ask if there is a motion for approval of the requested zoning relief at 2125 Madison Place.
Okay, I'll make a motion. I move that the Land Use Commission grant the requested major variation to allow a street side yard of 6 feet 6 inches, where a street side yard of 15 feet is required for an addition to an existing single-family home in the R2 Single Family Residential District.
I'll second.
So it's moved by Commissioner Lindvall and seconded by Commissioner Westerberg. Is there any further discussion? Hearing none, do I have to do roll call votes anymore, or can we just do, what's our policy?
Technically, no, but it is helpful for the minute taking, but it's at the discretion of the chair.
Go ahead and do it.
I'll go ahead and do it then for your sake, Ms. Ashbaugh.
Thank you. All right. Commissioner Halleck? Commissioner Hugo?
Yes.
Commissioner Johnson? Commissioner Lindwall?
Yes,
Commissioner Miranchev?
Yes.
Commissioner Pucktell?
Yes.
Commissioner Westerberg?
Yes.
Chair Rogers?
Yes, so with a vote to 8-0, the zoning request is approved. Good luck with your project, and just know that we aren't always this quick on a case, so. We will move on then to the second case that we have this evening, which is 3101 Central Street, 22 ZMJV 0076. And I will ask that that be read into the record, please.
You got it.
Lakeside Auto Rebuilders requests to amend an existing major variation condition required by Ordinance 105-019, Ordinance 27087, and Covenant 87-3359274 that requires termination of use upon transfer of ownership of the property. The site contains a legally non-conforming use of an automobile repair service establishment and auto body repair establishment, where said uses are not eligible, permitted, or special uses in the R4 General Residential District, Sections 6852 and 6853, or an eligible active ground floor use in the OCSC Central Street Overlay District, Section 615.14.7. The Land Use Commission makes a recommendation to the City Council, the determining body for this case, in accordance with Section 63810 of the Evanston Zoning Code and Ordinance 92-021.
Thank you. So just a little bit of clarification here. So this is a property that has operated under certain special use.
It does not have a special use. It is a legally non-conforming use.
Okay.
And it most recently went to the Zoning Board of Appeals in 2019 for a variation to expand the legal non-conforming use, which was granted. And that ordinance, as well as past historic documents, contain a condition that is now what is on the
So
table.
it's being what's triggering it being heard again is because the property is changing hands, or they're,
I'll let the applicant
Okay.
go into detail, but the issue at hand tonight is one specific condition within the previous variation ordinance. And because it's within an ordinance, the Land Use Commission is the recommending body, and the final determination is at City Council.
okay, I just wanted to clarify where we were coming at exactly. All right, thank you. So if the applicant will please come up and state your name and address for the record.
Good evening, Chair Rogers and members of the commission. My name is Christopher Canning. My office address is 1000 Skokie Boulevard in Wilmette. I represent Lakeside Auto Rebuilders. With me is the owner, Sarkis Tokat, who is a 50-year resident of the neighborhood, and his son, Armin Tokat, an ETHS grad who also works at Lakeside.
Mr. Canning, I'm going to stop you just for a moment so I can disclose that we do know each other professionally.
We do.
But we have not worked on any projects recently, but we have talked advice to one another
Yes.
over the years. So I just want to clarify that so it's out there in the public record so everyone is aware of that.
Yes.
So please proceed.
I know you all have had a chance to read the staff report and my letter to the commission, so I'm not going to go over that. But I will take a moment to say that when I got here tonight, I went up to Melissa and I want to know who wrote the staff report, because in my line of work, I see a lot of staff reports, and this one tonight was excellent, really, really excellent. And Melissa said she did it. So I just want you to know that other communities do a very nice job. The one tonight really is excellent. And so I'd like to thank Ms. Melissa for that, as well as bringing this matter before you. As Melissa was saying, this is an amendment to an existing variation condition. And though it's a very long description, it's a very straightforward request. Lakeside has operated in this location since 1975. As Melissa said, the last time they appeared before any public body was in 2019 to make an addition to the building, which was approved. The city council approved it, the building was built, and then the pandemic hit. And during the pandemic, Lakeside continued to work, and today they are averaging over 800 cars they are working on, because as you may have read, during the pandemic, more people drove fast, more accidents, more work. And of the 800 or so cars they work on any given year, over 60 to 70% are Evanston residents. So they really perform a valuable public service for the neighborhood as well as for the city of Evanston. What Melissa had said is what's driving this request is this is a non-conforming use. It's a business use in a residential district. Now, granted, this business has been a business like this has been on this site for almost 94 years. The first time Any permit was issued was in July 1928 for a grease trap, and then for a brick fuel oil selling station, November 1928. And so all this time it's been here, and the first time Lakeside with its current ownership was before your predecessor board and the city council was in 1987 seeking some zoning relief. And at that time, one of the conditions to granting the variations was that the use would terminate upon the passing of 4 individuals, Sarkis, his wife, and his in-laws, or if Sarkis himself ceased operating the business. Now, you're very familiar with uses running with the use or uses running with the land. I've never seen a case where a use runs with a family. And in 2019, when the request was made to expand the garage, that condition was carried over by the approval of the city council. And so what that means as a practical matter is today, if anything happens to Sarkis and he can't operate the business, then this non-conforming use would have to cease. And Armin and the 12 employees who work there would be out of a job. So what we're really here today is to talk about succession planning. Sarkis would like the opportunity to no longer run the business, let Armin run the business. And Sarkis and Armin would like the opportunity, if the situation arose, to sell the business to a similar either owner or a similar body that would carry on the same line of work. And if, as you read in Melissa's memo, often when there's a transfer of a business from one use to the same use, that's, quite common. Right now, as it exists, Sarkis can't do that. And so that's what we're asking for, is the amendment to the condition to no longer tie the use to the lives of 4 people and the operation of the business tied to the life of 1. So that's the request. It's not going to change the footprint. It's not going to change any setbacks. It's not going to change any hours. There's going to be no other change. It's just Sarkis and his family would like some certainty going forward that they can operate the business. If they choose to sell the business, that's another situation. And certainly if they chose to sell it to something that is outside of this business, then it would come right back before some body, a public body, to address that issue. That's the request.
I have a question. So what exactly is triggering the request at this time?
Sarkis is not as young as he was in 1987. And so literally we're talking about succession planning. Because if as we interpret the law, if, God forbid, something happened to Sarkis tomorrow and he could not operate the business, then under the conditions that exist today, Lakeside has no legal right to operate without Sarkis operating it.
So I'm familiar with special uses where we reviewed them, where ownership triggers the new owners to come before us, even though the use is staying the same, and I understand that's typical. This is a little strange because it's tied to an individual.
Right, as well as if he was no longer, or his wife and his in-laws have passed. So if he or his wife were no longer the owners of the property,
Yeah.
then again,
But that wouldn't necessarily trigger a sale.
it wouldn't trigger a sale, but it wouldn't mean that the use, the business would have to stop.
I understand. I
And-
understand what it would trigger, and that's the unusual part.
Correct.
But is there an option, should we consider an option where if the property is sold, it still has to come before us, but this other business of the family transferring within the family, we get rid of?
I think what I believe Sarkis would prefer would be, hypothetically, if Mike's Auto Body wants to come by Lakeside and run the exact same business out of the exact same building with the exact same hours, they'd like to have the right to transfer that. At this moment, they don't have that right.
And I guess my question, maybe this is for staff, is that are there any other special use properties that don't have the provision that they have to come before us if ownership changes? Are all other special uses requiring that?
Special uses are not required to come back due to ownership changes. It is if the impact changes.
Is the what?
If the impact changes.
Impact.
So
They
it-
expand the business, they expand the hours, they add on a
see.
new service.
I see.
Those
So-
sorts of things are,
what you could do is add conditions about how the current operations are. For instance, I believe it's by appointment only. So you could add a condition saying that operations must continue to be by appointment only. And in that case, then, if and when there is a new owner, and if they don't want to follow that, which would increase the impact, that would trigger them coming back here.
The conditions that were approved previously by the council, I think they're A through G that you identified, would those conditions transfer to a new owner if a new owner were to take over? Or would we need to include that in any kind of deliberation, new deliberation?
All conditions listed within the approving ordinance would transfer to the next owner.
So everything, including landscaping, limitations on use, hours, and that type of thing? Would
Correct.
continue. Does the city have any concern about this continuing as a legal non-conforming use? Is there any indication that you'd prefer to see residential on this site, if the site would change use?
I believe if the site were to change use, residential would be appropriate. I do not foresee that happening any time in the next even few decades, just given the past history of the property and that it's likely contaminated. So given that specifically, I think in this instance, it is appropriate to allow the continuation. I do have some pause about if there should be a condition requiring by appointment only to ensure that vehicles don't expand onto the street or end up potentially looking like a storage lot. But I would leave that to the discretion of the board.
Commissioner Huco?
Just as a matter of historical interest, back in '87 and 2019, a deal was cut. Variations in return for this commitment, if in the event that the owner were to die or no longer continue with the business. What was the thinking back then in terms of, at some point, one would want to sell the business or get out of the business? And, deal was struck. In return for the variances, there was a commitment made. I was just wondering what was the thinking behind it at that time, given that at some point one would want to sell their business or pass it on to someone who might be not one of the original four people.
So I can speak to 2019, and it was a very narrowly focused request. And with the understanding that these conditions that were in existence since 1987 would be carried forward. With respect to 1987, to be perfectly honest, I was in law school, and the attorney who was representing Sarkis has passed away, so I have his files. So the best way to answer your question is I'm going to ask Sarkis to come up and tell you what happened back in 1987. So if you give me a moment, Sarkis.
Good evening.
Good
I'm
evening.
Sarkis Tokat, on the Lakeside Auto, also the property with my wife. And what's the
So
question?
what happened back in 1987, and why was this condition attached back then?
Well, the 87,
I guess, why did you agree to it? Because you got something in return for it, and in return you gave up something. What was your
I
thinking in
didn't-
terms of
well,
why you would limit your ability to pass on the business?
I came to ask a permit to put a spray booth something modern to control the fumes and all that, or sprays that going out, which originally I was granted just very premature ventilation. And then that triggered to city and some neighbors to come to stop me operating. So that time in '87, I already had 13 years in the business, and I didn't want to give up that. That was my dream after 3 years coming to this country, having your own business. And somehow they granted me not the extension on the building, even though it was a hardship, just putting that spray booth. And that time it cost me like $80-some thousand with all the rules and regulations and sprinkler system and all that. I was okay with that operating. So, but I didn't think, or probably that time of my knowledge about these things, I thought as long as it's in the family, we can operate. But that was, I didn't think it was just for the land, not for the business. But now, later the years, say 10, 15 years before this, my son came in. So he's operating right now, and that's his future. So that's why we're here to ask, and along with him, we also have 8, 9 employees, which they've been us over the years, and I've been operating since '75 at the same condition. Nothing has changed. And my way of operating, or our men's, we're not open Saturdays. We're not open like after 5 p.m. We don't park outside of our permitted land. We're operating the same way, the best way we can to please everybody with our neighbors, which I'm sure they're all pleased the way we're operating the business. But the main thing, I'm here because I didn't think that time, my son is going to be in the business. How should I know? Like that, that was a long time ago. And with my knowledge that time, with the late Mr. Murray, I thought it was just the land, as long as land stays in the family, which my father-in-law and my mother-in-law owned it. I paid them a rent, and then I purchased later from them, and I'm still there. And that's why I'm here to ask something for my son's future, and then also my employees. I don't know if I made it clear what happened in '87. What happened in the city side or others, I don't want to go to details. Believe me, it was ugly, and I don't want to even remember what happened because all of the accusations and all that, they came after me. None of it was true, like with the EPA, OSHA, and all that. And we end up at the court, and the judge granted me that put my spray booth in a building. That's what I did. I don't know if I answered your question.
And I also think if you look in the staff report, there was also discussion about the overlay district that was going in at that time and the change to the zoning to try to remove small commercial uses like this and make it fully residential. And so my interpretation after the fact was this was just a way to keep that down zoning going. It was tied to, the individuals.
May I add something?
Please.
Well, at that time, I never got, or my in-laws has any notice from the city, they changed the zoning. That all came, because I think they changed it in 1985. We didn't get anything until I applied for permit to put a spray booth. So that's the whole thing started right then. That's why it started. And I really appreciate it if you consider, my son's future and his kids, and also 8, 9 other employees and their kids. That's why we're here. We're not going to change anything. Our hours, everything, we're limited. We're not adding any more business. And I've been here since 75, or actually 72 in Evanston. Thank you.
Thank you. Are there other questions from the commissioners? Commissioner Lindwall, you're looking.
Well, I just was going to make a comment that the Central Street overlay happened somewhere in the 2000s, probably 2006 or 7, somewhere in there, before 2010-ish, let's say.
Correct, that is when the overlay was established. I believe that downzoning has occurred on Central Street for probably a couple of decades.
Well, and also the zoning ordinance.
Well, the
was
zoning
totally
ordinance was 1993.
Right, right. So I mean, we're talking
A long
before
time
any of
ago.
our current rules came into place.
So I think that that's really all my comment for at this point.
All right. Are there any other questions for the applicant or Mr. Canning? If not, I'm going to ask if there's anybody else here who would like to speak to us on this matter this evening. And seeing no other hands, Mr. Canning, I'll ask you if you'd like to make anything in summation.
In summation, thank you very much for hearing us tonight. We appreciate the opportunity. We would ask a positive recommendation be made to the city council to grant the amendment to the variation. And that way Sarkis and his family can do succession planning. So thank you for your attention.
Thank you. Before I close the record, I have a couple questions for staff. Have we received any complaints anywhere on this business, and was there anything voiced in 2019? I was not on ZBA at that time, so I don't know if there were any.
The zoning office has not received any complaints, at least in the last 10 years. I don't know of any over any time, and I believe in the 2019 zoning board case, there were multiple letters of support. I do not believe there were any letters of opposition.
Okay, thank you. And all other conditions in 2019 were carried forward from the original agreement? The only thing
Correct.
that was the change was what you discussed earlier? Okay. With that, we will close the record and begin our deliberation. I will ask the commissioners if they have any thoughts to share. Commissioner Lindwall is moving toward her microphone.
Sure. I think that, and I don't have it in front of me, the only condition the condition that applies to the ownership was F, I believe. Is that correct?
I think so.
Somebody is looking at it. But it seems to me that you know, removing that one, and, you know, especially since my understanding is if there is an increase in activity, even with a transfer of ownership, that would trigger it coming back before us. And I think in reference to George's comment about special, you know, having special uses come with a change of ownership, I believe that that one case recently had to do with the cannabis, which I think is I think that's a unique kind of special use. So I don't think that the change of ownership, you know, is necessarily an issue. I think that it's maintaining the kind of the current level of operation, which apparently does not have a adverse impact on the neighborhood as far as we can tell.
Other comments from commissioners? If not, I will make my comments basically while I go through the standards. Again, we have standards that we must go through to find are met. We'll be going through I'm using the same 7 standards for a variation. The first one being the requested variation will not have a substantial adverse impact on the use, enjoyment, or property values of adjoining properties. I would say that this standard is met. This business has been in operations for decades under the current ownership. It seems like he has plans to hand it to another member of his family, which currently he is prohibited from doing under the current ordinance. And we have had no one show up here tonight to speak against a project, something that I would think in this particular neighborhood with the overlay district for Central Street, typically we have some people show up to voice opposition to something there. So I would say the fact that no one has showed up to that means that the business is operating in a manner that makes them a good neighbor. So that standard is met. Number two, the requested variation is in keeping with the intent of the zoning ordinance. We do allow legal nonconforming uses to continue to exist. Again, this property has been operating under in the manner in which it is currently operating for several decades. And there is no reason that I would see that allowing this to continue to operate would stand in opposition to the zoning ordinance as it is currently written. Number three, the alleged hardship or practical difficulty is peculiar to the property. We've already had some discussion about this, that quite often this raises an interesting little dilemma, because quite often we make our decisions based on the property, but we're faced with a decision tonight in which the human element has come into play. So the fact is that we have created a particular hardship on this particular property because of the fact that we have made a condition that sort of steps outside of typical land use by making it based on the owner and naming individuals that can own this property without a change to the ordinance that governs this business to exist. So I believe that standard is met. Number four, the property owner would suffer a particular hardship or practical difficulty as distinguished from a mere inconvenience if the strict letter of the regulations were to be carried out. We've heard testimony that this basically would cease the operations of this business should something happen to the present owner, and therefore we would have several people who would be immediately without work. And obviously that creates a practical difficulty and hardship as opposed to an inconvenience. So I believe that standard is met. It also would probably lead to a property that would become an empty property that would sit and not be touched for a while because of the remediation efforts that would be needed in order to make it a residential establishment. Number five, the purpose of the variation is not based exclusively upon a desire to extract additional income from the property. We've heard testimony this evening that there are no real plans to sell the property at this particular time, and that it really is to allow the property to continue to operate with the son of the present owner becoming the owner in the future, so that his father can retire and no longer have to be working here in order to keep the business open. So I believe that standard is met. Number six, the alleged difficulty or hardship has not been created by any person having an interest in the property. We've heard testimony that the fact that this was a legally non-conforming parcel of land and operation, and the city has actually the one who has created the hardship for the owners by creating downzoning and placing conditions that we normally do not place on properties. But I do not believe that any owner of the property or anyone with an interest in the property from that side has created any issues. That standard is met. And number seven, the requested variation requires the least deviation from the applicable regulation among the feasible options identified before the Land Use Commission and the City Council. And I believe that this is a simple thing where he's not asking for a drastic change in all of the other conditions to which he's agreed over the years. So I really believe that making a plan for succession of the business is a minimal change and is probably about the least that he could be asking for, considering the other conditions that are currently placed on this property. So I believe that is met. Is everyone in agreement with my finding on standards? With that, I will ask if there are any conditions that anybody is concerned about out of the initial group, or that feel needs to be strengthened, added on, or anything like that. Commissioner Westerberg.
I would suggest that we add a condition that requires any new ownership to continue the by appointment only operations. just to protect the residential neighbors around them.
And I'm assuming, just by a shake of the head, that that would be an agreeable condition placed on the applicant. They seem to have no issue with continuing under that operation. Anything else that anybody has an issue they'd like to raise? If not, I will ask if there is a motion to recommend approval of 3101 Central Street, 22 ZMJV 0076. That basically we remove the condition, which was F in the existing ordinance, to allow a succession plan to be created for the owner.
I'll give it a try. I move that the commission approve the request from Lakeside Auto Rebuilders to amend the existing major variation condition required by ordinance 105-0-19 and 27-0-87 that requires the termination of use, that would involve removing condition F that was in place originally, and adding the condition that any new use be required on an appointment-only basis moving forward.
And that if they wish to change that, they would have to come back.
And that if they wish to change that, they would require a meeting with the commission.
Thank you. It has been moved by Commissioner Westerberg. Is there a second?
I'll second.
Commissioner Lindwall with the second. With that, I will ask for, or is there any further discussion? Hearing none, would you please call the roll?
Commissioner Halleck? Commissioner Hugo?
Yes?
Commissioner Johnson? Commissioner Lindwall?
Yes.
Commissioner Miranchev?
Yes.
Commissioner Pucktell?
Yes.
Commissioner Westerberg?
Yes.
Chair Rogers?
Yes. So with a condition, or I'm sorry, with a vote of 8-0, it will go forward to City Council with a recommendation for approval. And staff will let you know when you'll be appearing before P&D and City Council. So good luck and thank you. The next item we have on our agenda this evening is for 1012, 1016 Church Street. And I don't know who is Ms. Ashbaugh doing that one, so if you'd please read that into the record.
Chair Rogers, if I may ask for clarification as I'm clarifying the motion.
Yes.
Did you mean that if any new ownership wanted to change any conditions, that they only be heard by this body, or that they would just go through to City Council all the way again? Because you said this commission, I just wanted to clarify.
It would come back before us, is the way I intended that to be.
But it would then go to the city council.
It would go to City Council then,
Okay.
because it would have to come to us first as a recommending body. Yes, I'm sorry.
Okay, I didn't understand. I wanted to clarify if you intended that you
No.
wanted the land use commission to be
No.
the determining body, or
Nope,
you
nope,
intended?
I can't
Okay.
make that determination, unfortunately. So yes, it would follow the same process that it is going through right now.
Okay, thank you. I will read the next item into the record. For the property located at 1012 through 1016 Church Street, case 22PLND-007, a major adjustment to a planned development. Janet Mullet, applicant, Northlight Theater, submits for a major adjustment to the planned development approved by ordinance 114-0-19 in the D3 Downtown District. The applicant is requesting to modify the approved building elevations. The Land Use Commission makes a recommendation to the City Council, the determining body for this case, in accordance with Section 6-3-6-12 of the Evanston Zoning Code and Ordinance 92-0-21.
Thank you. If the applicant would like to come up and state their name and address for the record. Yes.
I have to disclose that I know Mr. Smith, who is the principal of the architectural company. We worked together many years ago, but that's the only thing that now I'm not involved in this project.
All right, thank you.
Good evening. My name is Tim Evans. I'm Executive Director at Northlight Theater. This is Janet Mullet, who is our Managing Director and Project Manager for the property that we have purchased at 1012, 1016 Church Street. And we are seeking a modification of the elevation, the front elevation of the building and facade of the building, and we are working with Craig Smith from Eichenhoff Saunders, who is our architect, and he'll explain what we're seeking here tonight.
Thank you.
I'm Craig Smith with Eichenhoff Saunders Architects, and I've been working with Northlight for a number of years on the project, including going through the plan development approval back in 2019. Since that time, a lot's happened in the world, and the reality became apparent during the pandemic that we had to make some adjustments because of supply chain, and then the war in Ukraine happened. And I don't know if everyone knows, but one of the largest glass manufacturing plants in the world is in Ukraine, and glass prices just skyrocketed. So we decided to relook at the facade. And in the intervening 2 years, we kind of came to the conclusion that we wanted a kind of a simpler facade to create more of just a kind of a blank palette. So when you're driving down by Church Street, you're really looking at a very simple facade, looking into the lobby and seeing what's there. So we kind of wanted to downplay the architecture and make it just a simple architectural expression of glass and aluminum. It's still an all-glass facade. It's going to be clear glass so that you will be able to see through into what's happening in the theater, because one of Northlight's goals is, of course, to activate the street and be really a part of the downtown community. So the building itself is the same. It's the same height, the same use, the same scale, and everything is really the same. But it's just the literal articulation of the facade. So now it's a gridded, it's a black aluminum grid, and then I've got a sample of just a clear glass. And we are using the fritted glass for the bird glass. So I don't know if you can see it, but there's a frit in there that the birds will not crash into the glass, hopefully. So you can see that it's still a two-story building. And then on the second floor, we have the rehearsal hall now. And the ground floor is all the public lobby, which will be open, hopefully, more than just the times of the theater. So it's a very open and transparent expression as you're driving by Church Street. So we feel it's an improvement to the facade. Actually, I really like the way it turned out, so we're hoping you'll agree with this.
Other questions? Commissioner Halleck?
My first question is for staff. And this gets back to the process that we talked about, variation, or changes, minor changes, major changes. This is considered a minor change, and it was listed as a minor change in the new language that we approved. So I just want to be clear that minor changes still come before us, or is it at the discretion of the staff, or what? Because this is a facade change, which is...
The text amendment for major and minor adjustments has not yet proceeded to City Council.
I understand that. I'm asking about what we talked about.
Assuming it is approved, this would be a minor change which would go straight to P&D and City Council. Since it does not affect any site development allowances, it would skip this body.
Right. Okay. I guess my thought on this is that I consider this a fairly significant, call it major or minor, I don't know, but fairly significant request. And I just think this is an example of something that we should review. But we've talked about this before, but I just wanted to raise my concern, which I expressed when we talked about this text amendment, that we wouldn't see things like this. And I think we should see them.
Other questions?
Yeah, I have other questions, okay. So you said that the war in Ukraine and the fact that Guardian, I think it's Guardian, right, has a plant in Ukraine, and that's the reason why you can't get this glass.
Well, it's really the
If you could
cost of glass.
step forward, please, to the microphone so you can be...
Really, the cost of glass went up dramatically in the past year due to the fact of that. It's not the specific glass or the plant, but the price of glass skyrocketed. So the cost of our curtain wall went up by about $500,000.
So even glass made in China, even glass made in any other Guardian plant in the world, and they're all over the place?
Just drove up the general price of the.
Price of glass.
curtain
So really, it may be Ukraine, it may be other things, but really what you're saying is that the cost of the building has gone up.
Yeah, the whole, yeah.
And this is okay, so my second question is, this is an aesthetic opinion, I guess, but did you consider, what other alternatives did you consider? I mean, to me, this is quite a step down, and that's an aesthetic opinion. What other alternatives did you consider? Or did you?
We looked at a number of alternatives, but working with Northlight and ownership, they really liked the design, this design that we came up with. It's a very, it just seemed compatible with the scale of the building, and we just wanted to go with a much simpler expression. So we actually, we being us, the architects and the owner, like the new design. That's just our opinion. I understand everyone has their own opinion or judgment.
Commissioner Westerberg?
So a question for staff. This original facade was obviously approved with the planned development when it came before, so the city has an expectation of what the building will look like. What is the concern here that you have in terms of who does oversee this? If you grant site allowances, if you grant certain developments the right to build, but you end up with a change, a pretty, as Commissioner Hollick said, a pretty determined change in the appearance. And I ask that only because it's, without some design oversight, you can end up with any situation where a developer can say, you know, over the last 2 to 3 years, as we've been developing this and designing this, costs have gone up, we're going to have to change this. We're going to have to, we've seen this already with a couple of other situations. I'd like to know, as far as the city is concerned, where you want assistance and where you think you need that assistance to make sure you're getting what someone did approve several years ago.
So as part of the building permit process, the project would go to the Design and Project Review Committee for review of the materials and to make sure that all of the materials match what was approved. The city is currently looking at changing how the Design and Project Review Committee operates. That may or may not include establishing a new committee that has some additional oversight on that. The discussions are ongoing, and we do expect a text amendment to proceed to this commission to specifically address those concerns.
All right, so again, in this particular situation, it comes before the Plan Commission, and I guess my question for the other commissioners to talk about a little bit is, how far involved do we want to get with design? And how far involved do we want to get with the idea that how many changes can you allow a developer to make as things roll along in the process?
So this would be my response, is that we have passed along to City Council an ordinance, proposed ordinance, that says that if it is a site allowance, it comes back to us. If it is not, it goes to P&D. Anything that goes to P&D, if City Council feels it is a significant change, can return it to this commission on a referral. But that's the measure that is in place currently, or will be in place if City Council adopts the ordinance, the text amendment.
So the only other comment I will make is that you can have a project approved several years ago. You can have changes then come up as the construction moves forward, and you will end up, the city can end up with a very different looking project or development in that case.
And the approving body, the determining body in either case is City Council.
Which could be a new city council.
Right.
Okay.
Another question. Did you consider, the budget is the whole budget, you know, and glass is one part, not insignificant. Did you consider changes to any other materials or anything else about the project that might be internal that wouldn't affect basically every citizen who walks by this building or drives by this building?
Oh, absolutely. I mean, we went through and Tim can speak to that, but we went through a long process of, you know, the standard value engineering, but of evaluating almost every aspect of the building in terms of the size of the rooms, like on the building back on the alley, we pulled in a few feet to make it actually a smaller building in volume by making a larger space off the alley. So yes, we went through and made hundreds of decisions that to address the, I mean, it was a large cost problem that we had, like a lot of people are having over building costs.
And if I can, I would say that when we first got our cost estimate, which was prior to COVID, 2019, early 2020, we had a certain price for this building and with the original facade. And then by the time we sort of stopped our operation for a while, and then we restarted this project, bought the property. And then when we looked at a second quote on the building itself, because we're a nonprofit entity and we have to raise all this money ourselves, the cost skyrocketed with everything, as you know, steel and wood and concrete and glass in particular. So we needed to sort of reduce the cost of this building without really reducing the impact of this building. For us, the last thing we really wanted to change was the theater space itself, and we wanted to maintain that and make sure that the activity in the actual theater and the art wasn't changed. So we did a couple of things, which was, as Craig said, we shrunk the building, we shrunk the basement. Frankly, digging, as you know, is very expensive, so we modified the size of the basement and made sure that it conformed to what we had said before, but it also, we shrunk it. So we shrunk a lot of things. None of them were major changes, except we were going to have a balcony in the theater. I don't think we're going to have a balcony now, because that's $1 million+ to put a small balcony in there. And we found other ways to maintain the integrity of the theater and, frankly, the seating capacity of the theater. But the glass front was a real killer for us, in the sense that this glass was, the other design had 2 layers of glass, and it had this wavy curtain effect that we all loved. But when we priced it out and found that the costs were enormous at this time after supply chain and Ukrainian issues and just the cost of glass, we decided that we really needed to address this so that we could, basically get this building built. So we felt that a Midwest industrial look to the building, which actually it had before, it just had this curtain wall. If you look at the other photo, you'll see that instead of a black grid, there was a white grid underneath all of this. So we wanted to maintain that look and that really open look. And I think this the new design allows us to do that, but also gives us a little bit more of a Midwestern industrial feel and look to it, which really works to the ethics of our theater company. So those were the issues that we had to deal with. Yes, it was cost mostly, and we felt the supply chain, we're not sure where this glass was going to come from in particular, because it was very specialized and custom glass, and we felt that it was something that was beyond reach for us cost-wise.
Commissioner Huco?
So if you were to go back to the original design, you'd have to raise the additional money now to take into account your increased costs. What would the delay be in terms of needing now to raise this additional? Are we talking 1 year, 2 year, 3? I mean, what would be the delay in getting the building built? And is it even possible, in your view, to raise the additional money needed? Because you're already, right, raise the additional money needed to comply with the original design.
Sure. Well, I would say the cost of the entire building has risen, right? So everything in the building has gone up. And so we've already had to up our fundraising goals because of that. The goal here for us, for Northlight and for our board of directors, and frankly for the community, is to get this building built in a timely fashion. And I couldn't tell you what another $750,000 would take to raise, but I think that's what we're looking at if we at all wanted to do the original facade. It's not an easy fundraising environment between inflation and the stock market and the coming recession that everybody seems to talk about. However, we are making progress and we are getting to our goal. But I want to get to our goal, and ideally, if we can have this modification, this would help us not delay this project anymore. I'm not even sure we can get the glass, even though, that would be something we'd have to determine if that's possible. So,
Commissioner Westerberg?
Question on the new design. What do you see that relating to elsewhere along the streetscape there on Church? Do you see it kind of picking up any motifs or themes that are around there, or do you find it something that you wanted to stand out in this sort of industrial Midwest way?
Yeah, I don't think it relates to anything specifically. I think the scale of the building being where the visual part is a two-story, is height-wise and scale-wise, it's similar to the buildings. Like the building next door is a two-story masonry building with a very simple punched open windows. So, no, I don't think it has any specific relationship, but in terms of just an urban context and a very simple modular gridded facade, I think it's pretty typical in a Midwestern urban setting.
and I would add that it relates to the downtown public library. Has a Midwestern ethic to this. The new facade of the Fountain Square building, the pie-shaped building, has this kind of look as well. There are others in town, but for us, we just felt that this had a little more meatier industrial look, which we liked.
Has there been a change in the overall percentage of glass that you're using along the facade? To my eye, it looks pretty similar in terms of percentage of glass.
It's it's pretty much exactly the same. So the whole width, the site is 100 feet wide, and other than the concrete piers at each end, it's continuous glass. So it's exactly the same dimensions, vertically and horizontally. And also probably the percentage of mullions is very similar. Like Tim said, before we had a serrated or segmented portion, so there's technically more surface area glass, but the facade dimension is still the same.
Okay. Other questions from the commissioners? At this point, I'll ask if there's anybody else here this evening who wishes to speak to us on this matter. And not seeing anyone, I'll ask Mr. Evans and Mr. Smith if they have anything they'd like to say in summation before we begin our deliberation.
The only thing I would say is that I brought this to the attention of the city when we knew we were making some changes, because I had read about the project at Howard and Chicago Avenue. And it felt to me like the right thing to do would be to notify the city and bring it as a good citizen to everybody's attention that we needed to change the facade of this building. So that's frankly why we're here.
All right, thank you.
Thank you.
With that, we will close the record and begin our deliberation, and I'll ask for general thoughts from commissioners. Commissioner Johnson?
I do agree with Commissioner Halleck in his comment that the proposed new facade design is a, I can't remember how you put it, is a downgrade aesthetically, in my opinion, than the original approved design. And I'll reiterate something that I've mentioned before, and that, you know, there are circumstances with Russia's attack on Ukraine and rising cost, inflation, supply chain, but there are always issues associated with construction. Costs go up, you know. And I'm sympathetic with their plight, but this is it's, you know, it seems that one facade was approved because of cost issues, and other an alternate, a downgraded alternate is being proposed, and again, as Commissioner Halleck mentioned, that the interaction with the facade is anyone who's using the street, any pedestrian, any driver. So those are just, you know, my thoughts.
Other commissioners?
Yeah, as often happens to me in these hearings, is that I come in with one opinion and then leave with another. And in this case, you said some really good things, I think, when you guys were up here. And one of them was that you did read about the other project that had a similar situation, and you decided on your own to come in, which I think it was the right thing to do and certainly appreciated. I'm saving my opinion for the facade the last, but the other thing I appreciated is that you did have an overall cost-cutting, you know, session. Because, listen, Costco, this is a crazy business, and, you know, a building is a crazy business. I think running a theater is a crazy business, and fundraising and all that is, I think, really difficult from what I know of it. Even though I made the comment about all the citizens walking past the building, I also do appreciate that you're a theater, and your first obligation has to be to the performance. And so I hope you didn't downgrade that experience for the theater goer, and it doesn't sound like you did. So all those things, so listening to you, I had a much better appreciation for your situation. I wasn't happy, I'll tell you, when I read that the reason why you did this was because of the war in Ukraine. And I thought to myself, well, wait a second, glass is available everywhere. Guardian has plants everywhere. You know, you could go somewhere else other than Ukraine and get your glass. I don't know the details of all of that and what's happening right now, so I'll believe you when you say that the overall cost of glass has gone up like other things. I think in the end, the facade is it's unfortunate. I think that the facade that was originally approved is more interesting than what is going to be built, apparently. But again, listening to you, I think that Evanston is excited, very excited to have Northlight come downtown, and this has been a long struggle, I think, you know, for you especially, but also for Evanston to get you guys downtown. So I'm overlooking what I think is an unfortunate situation and saying if this is overall, if this is the best we can do, then better is better than not having a theater. So.
Yeah, I'm in favor of granting the change as well. I think that the designers are not making an egregious change. It's pretty reasonable. The changes aren't affecting any of the previously granted variances, and they're doing what they have to do. It is, I agree with the unfortunate comments about the quality of the facade. That is unfortunate, but so are wars and pandemics. So I'm in favor.
Commissioner Lindwall?
Sure. You know, I keep thinking about the context of this building, and frankly, I think that the proposed facade, you know, relates a little better to the Shan Morahan building across the street from it in terms of facade and materials. But, and again, I also appreciate you coming and bringing this matter to us early enough in the development process so that we can weigh in and the city council can weigh in. So I think that's important. So I'm in favor of the proposed change.
Thank you. Commissioner Huco?
I'm also in favor of the change. I mean, I do prefer the original facade, but, you know, the theater, I think, is extremely important for the city. There's excitement to bring the theater in. I think it needs to happen. And, you know, we are in unusual times. Yes, in the construction business, costs do go up. It's a risk one always undertakes, but these are unusual times. Once in a century pandemic, a war that we haven't seen since World War II, and with a difficult fundraising environment. And we have to remember this is a nonprofit organization. So I'm, you know, I don't want to make the perfect the enemy of the good. And so I would echo the thoughts of my fellow commissioners in terms of supporting this request.
Thank you. Anyone else? Commissioner Miranchov?
So I will vote yes for this application. In my opinion, the previous facade was better, my opinion, but 2 reasons for yes. First, we really need this theater downtown Evanston, and second, knowing the process, as mentioned by Mr. Smith, of value engineering, I know that they did everything to reduce the cost. So probably this is the optimal, I would call it, solution between aesthetics and value engineering and construction requirements. So I'll vote yes.
Thank you. I think we've heard from everyone. Commissioner Westerberg, were you going?
No, I'll echo that. The project is an important one. Evanston needs it. It's good to see it. But I do think the facade downgrade is unfortunate.
Thank you. I'll just make a couple comments before going through standards, and I'll say that to my untrained architectural eye, that I do notice a difference in the building, but I feel that if this building had been the one that had been presented to us, I think a lot of people would have been very happy with this. I think a lot of people are disappointed in not getting what they were shown. But I think that this building in and of itself is a nice aesthetically pleasing building. I'm happy that we are keeping roughly the same amount of glass on the facade. And so I think the project is a nice project. Is it as nice as the last one? No, but that's sometimes you can dream big and reality comes and hits you in the face and you can't get what you wanted. With that, do you want to bring up the standards for, because I don't have those printed. Actually, maybe I do have those printed out. No, I don't have those printed out. Are these the new ones? Yeah. Okay, I do have these printed out. So the first one is we have to go through the standards for a planned development, of which there are 5. The first one being the requested site development allowances will not have a substantial adverse impact on the use, enjoyment, or property values of adjoining properties that is beyond a reasonable expectation given the scope of the applicable site development allowances of the planned development location. The one thing that we have discussed tonight a little bit is that there are no changes in the site development allowances. We're not being requested for additional height or density or anything like that. So this standard really is met under the original plan that was approved in 2019. Number two, the proposed development is compatible with the overall character of existing development in the immediate vicinity of the subject property. We've heard a little bit of back and forth on this, that although the building does not necessarily lean into any adjoining property, there has been discussion from at least one commissioner that feels that the design of the new facade actually is more in keeping with the neighborhood, which is basically a lot of masonry type buildings along there. I believe this standard is met. Number three, the development site circulation is designed in a safe and logical manner to mitigate potential hazards for pedestrians and vehicles at the site and in the immediate surrounding area. Again, we have not heard anything that is being changed on this particular property or this particular project, and therefore this standard is unchanged from the original 2019 ordinance. Number four, the proposed development aligns with the current and future climate and sustainability goals of the city. We haven't really discussed anything there except for the fact that it's not really a sustainability or climate goal, but one of the things that is very important to the city of Evanston is using glass that is bird-friendly and mitigates damage to our to birds traversing the city. Number five, the public benefits that are appropriate to the surrounding neighborhood and to the city as a whole will be derived from the approval of the requested site development allowances. Again, we've not discussed site development allowances in particular on this project since they are unchanged. However, we have heard a lot of discussion about the benefits the public will derive from bringing a noted theater back into Evanston after several decades away. I don't remember the exact number of years, but I know this has been a topic of discussion in the city for a number of years. So there obviously will be a great public benefit added by their return. Is everyone in agreement with my finding on the standards for planned development?
Yes.
The next set of standards is the standards for special uses. Number one, it is one of the special uses specifically listed in the zoning ordinance. A theater is permitted in our downtown core area and was approved in 2019. Number two, it is in keeping with the purposes and policies of the adopted comprehensive general plan, and the zoning ordinance is amended from time to time. As mentioned, bringing arts and theater into our downtown area is part of the comprehensive general plan. It does encourage additional traffic into the downtown area, which helps generate tax income on surrounding properties, as well as increase sales at restaurants and those sorts of venues in the area. Number three, it will not cause a negative cumulative effect when its effect is considered in conjunction with the cumulative effect of various special uses of all types on the immediate neighborhood and the effect of the proposed type of special use upon the city as a whole. I've heard nothing this evening that would cause a negative cumulative effect on the particular area, because again, the impact of this particular project has not changed. What we are looking at is a facade change, and we've had several comments made about that already. Number four, I'm sorry, it does not interfere with or diminish the value of property in the neighborhood. Obviously, having a functioning space in the downtown area that replaced a semi-functioning restaurant, I believe, was as part of the block that you've taken. I can't remember what else was there at this particular time, but obviously this will generate much more traffic into the area and should have an increase on property values in the downtown area, as well as generating additional income for the neighboring properties. Number five, it can be adequately served by public facilities and services. Nothing has changed here from 2019. Number six, it will not cause undue traffic congestion. We didn't really talk about this. Again, this was something that was approved in 2019, and I will just note that this being in our downtown area, we do have several parking garages in the area as well as public transit in the area, so I don't anticipate any additional traffic congestion. Number 7, it preserves significant historical and architectural resources. There are no historical areas there or architecturally significant areas there on this particular site, and so that standard is met. Number 8, it preserves significant natural and environmental features. Again, nothing really has changed here. I will note that although it's not technically an environmental feature, the inclusion of bird-friendly glass, which is something the city has really emphasized of late, can be considered an environmental feature because it does have an impact on wildlife. Number 9, it complies with all other applicable regulations of the district in which it is located and other applicable ordinances, except to the extent such regulations have been modified through the plan development process or the grant of a variation. There's no reason to believe that this particular applicant would not meet any regulations that the city has required of them so far. I will note also for the record that the applicant of their own volition did come to the city when they realized there would be a significant change, allowing the city to respond to that proactively instead of reactively. So I do thank the applicant for that. Is everyone in agreement with my findings on the standards of special uses? Is there anything else? Do I have to go through those guidelines that aren't really standards?
Staff determined that is up to you.
My answer is no.
There are slides for them if
My
you
answer
would
is
like.
no. Since they aren't really standards, they are guidelines. I will ask staff to please make sure that those are adhered to so that I don't have to go through those because they aren't really actual standards that we can follow easily. With that, is there any other conditions, comments that people would like to have added in before we make a recommendation to City Council on 1012 through 1016 Church Street?
Yeah, the only condition I want to add is just to make sure that the new material is still in compliance with the city's bird-friendly ordinance.
All right. With that, I will ask if there is a motion for a recommendation for approval to City Council.
I'll recommend approval of the revised facade design.
Okay. So that's with the condition that.
With the bird-friendly glass.
Okay. Is there a second?
I'll second.
Seconded by Miranchev, moved by Halleck. Any further discussion? Hearing none, would you please call the roll?
Commissioner Halleck? Yes. Commissioner Hugo?
Yes.
Commissioner Johnson? Yes. Commissioner Lindwall?
Yes,
Commissioner Miranchev?
Yes.
Commissioner Pucktell?
Yes.
Commissioner Westerberg?
Yes.
And Chair Rogers.
Yes. With a vote of 8-0, the project will move forward to the City Council, to their P&D committee first, and with an 8-0 vote, and good luck with your project. Thank you. And with that, we will move to our last case of this evening. I believe, Ms. Klotz, you're handling this one?
2012 Maple Avenue, 22 ZMJV 0075. Marcin Kawa, contractor, appeals the zoning administrator's decision to deny minor zoning relief, case number 22 ZMNV 0059, to construct a two-car detached garage with proposed building lot coverage of 43.8%, where a maximum of 40% is permitted, section 6866, and impervious surface coverage of 57.4%, where a maximum 55% is permitted, section 6869, in the R4A General Residential District. The appellant was denied zoning relief to construct a two-car detached garage. The Land Use Commission is the determining body for this case in accordance with section 6388 of the Evanston Zoning Code and Ordinance 92021.
Thank you. You are the applicant?
No. Mr. Chairman, my name is Stephen Peck. I am counsel for Marcin Kawa, property owner applicant, who is present.
All right.
Also present is Walter Okoczynski. He is the construction project manager and is in the property on a daily basis. And Jason O'Byrne is a real estate broker for Mr. Kawa, who can provide testimony or answers about any questions concerning feasibility of sales of the property with a 1 or 2 car garage.
All right. Thank you. If you would go ahead and present your case to us.
Mr. Kawa certainly disagrees with the administrator's decision to deny the minor variation application for the construction of the 2-car garage. Although he does agree with some of the administrator's discussion in her memorandum to the commission concerning the standards. And I want to start with really stressing that the difficulty we're rising here is for a non-conforming lot size. The old structure, as she flipped through the photographs before, showed I believe, a commercial structure with 2 apartments, either one behind, 2 above, or 1 above and 1 behind. Apparently, that structure was condemned by the city prior to Mr. Kawa purchasing the property. When he purchased the property in early 2021, he was intending to submit demolition permit application and a permit application to develop the property as a single-family residence with a 2-car garage. But the city's request, he put off the application for the new buildings, for the application for the demolition permit, and demolished the building right away. Shortly thereafter, he submitted the application for the single-family residence and the 2-car garage. There was back and forth between the architects and the zoning department, and it was decided to go ahead and construct the residence itself and put off the 2-car garage or construct a 1-car garage with a 1-car pad in the rear. As time went on, the construction of the residence is currently ongoing. There has been no construction on any garage. And as construction of the residence was ongoing, I believe that Mr. Kawa finally came to the realization, and Mr. O'Byrne can testify to this or answer questions to this, that it would be extremely difficult to sell the residence with only a 1-car garage. One other point that I wanted to make that I'm not exactly sure if the administrator was aware of, and this affects the permeability of the land itself. And the permeability of the land would influence the impervious cover. And we understand that part of the purpose of limiting the impervious cover is to prevent flooding, prevent surface runoff, et cetera, et cetera. Mr. Kawa commissioned a geologist to do 2 soil borings and opine on the permeability of the soil at the property, and this was in, I believe, May of 2021. And I have several copies of the May 2021 report from the geologist if the commission would like to review that. Again, I don't know if the administrator saw this or not. But what this geologist found was the soil at the property is sandy soil down to about 17 feet, in which case it becomes silty clay. And the permeability of the soil is very good. And so, for instance, either Mr. Kawa or Mr. Okoczynski could tell you that one of the first things they did when constructing the residence was to dig the sump. And that was earlier this year, and as yet, they have not put a pump into the sump. There's been no need to as yet, and I asked about yesterday. I live in the southwest suburbs. I don't know exactly how much rain you got here. We got quite a bit yesterday. There's no water in the sump now, so it's just all draining into the soils around the property. And again, we believe that we agree with many of the commissioners' comments about the standards. We certainly, we have in our appeal of the decision, we included a couple of photographs showing the alley, all the garages that are on the alley. Most of the adjoining properties have two-car garages throughout the alley. That's the old building. It's an attachment to the appeal of the zoning administrator's decision, so I think it's further up.
Thank you.
There we are. This is the
got lucky.
alley behind the prop. That's the next door two-car garage. I think that's 2014. The previous photo, this is 2010, so I think that's to the north of the property question. That shows a three-car garage, could even be four, and it looks like a coach house above the garage. And I think what you'll see in the previous photograph, okay, that's 2014, which was shown before. There we are. The property without a garage is 2012. The property to the right in the photograph is the blue garage. That's either a 3 or 4 garage with a coach house above. And the property to the left is the white-colored two-car garage. And the third or fourth photograph shows there are several two-car garages down the alley. Again, without agreeing to the administrator's decision itself, we agree that the difficulty is really created by the non-conforming lot size. We have taken steps to, at least for the impervious lot coverage, to use pervious materials, walkways to the house, to the back. Instead of concrete, they'd be either paver stones or paver stones with separated, so it allowed more soil or grass surface in between the semi-pervious building materials. And we believe that the residence currently being constructed is fitting with, the size of the residences in that block, and that the two-car garage would be fitting with other properties in that block for off-street parking. The two-car garage would encourage on-property and off-street parking, which would minimize congestion on the street. And although we realize that we are slightly exceeding both the lot area coverage, the building area coverage and the impervious lot coverage. These are not large deviations, and again, because of the particular nature of the soil, I think the risk of flooding and or surface runoff is small. And we have the owner, his project manager, and a real estate agent who could ask or answer any questions you may have about how the two-car garage would affect the area, and really the feasibility of being able to sell the house with only a one-car garage.
So I have a question for you. The owner of the property bought the property in the hopes to redevelop it, in the plan to redevelop it.
That is correct.
Okay. And in the plan to redevelop it, they have built the house, but not the garage.
That is correct. What you see here is a photograph taken about a month ago by Mr. Okoczynski, and I've been informed that it is, the garage area or the pad area, whatever, is in that same condition today.
Okay. So there's been no more development on the actual lot coverage
Correct.
beyond what this picture is, even though it's a month old?
Correct.
Okay. You've mentioned the permeability of the soil. Are you arguing that the permeability of the soil is not affected by the addition of a garage?
No. What I'm trying to state is, we know that by putting any impervious cover over the soil will affect the amount of, snow melt, rainwater percolating down into the soil on the lot. We understand that. The only reason I bring that up is to say that the soil which is on the lot is reasonably permeable. And so that water which falls onto the lot, certainly if it falls on the alley, it'll rinse off. If it falls in the sidewalk, it'll rinse off. But if it falls on the lot, it is more likely to percolate downward in sandy soil than in silty clay soil. And we're not hitting silty clay, according to the geologist, to about 17 feet.
Okay. Do other commissioners have questions?
Yes.
Mr. Lindwall?
I just want to understand the sequence. I understand that you're dealing with a substandard lot. The old building was demolished, and so then the owner, decided going to build a single-family house with a two-car garage. Now, obviously, there are, site development allowances and building lot coverage required to, build a conforming house. So I just want to understand the sequence, so that in order to meet the requirements, the city determined that, you build the house to the size that it is if there was a parking pad or a one-car garage with a pad, and then meet the requirements. Why not make the house smaller so that the two-car garage would fit?
I think that's probably a question for Mr. Cower and Mr. Ogden.
Okay.
Hello, Marcin Kawa, owner of the 2012 Maple. So it was very long process to get the permit. So but there was a previous owner reached out to me to build a house for her on the site, and the city was asking to demolish the existing structure because it was a dangerous condition. So she was like a second owner that was asked to demolish this building. So she decided she will not do it. She asked me if I want to buy it from her and do it. I said, yeah, why not? And I did this. So we applied for the permit for new construction with the two-car garage and the demolition permit as well. Demolition process was much quicker thanks to the city, because they want to speed up the process because they were afraid this building gonna fall down on the neighbor property. So I got the permit within the 3 months, and the new construction permit was, dragging the feet. There was a lot of back and forth between my architect and the zoning and the building. And after, I bought it January 2021. I got the demo permit April 21. I knocked down May 21, and I was promised by the city that my permit for the new construction gonna be done very, very quick, which is, didn't happen. It took another, 8-9 months. And on the very beginning of the process, I was told that, oh, by the way, the two-car garage cannot be two-car garage, it needs to be one-car garage, which is, I'm doing this for 20 years, and I never heard of something like this, that, single-family house, that's kind of usual thing, having a two-car garage. So I was so tired of the process, waiting for the permits, paying the, fees to the bank, property tax. I had the temporary fencing on the property with the temporary toilet. It was costing me every month the money, and I said, okay, fine, let's get this permit, let's start the construction, and I be dealing with this two-car garage process during the construction process, right? So we reached out to the village about the two-car garage permit. We got denied, and there was back and forward, and 6 months later, I'm here right now in front of you, asking for me, usual thing, having the two-car garage. I mean, now in these days, family has the usual thing, having the two cars, and nobody wants to keep the car on the front of the building, on the street. They want to have, cover for the robbery, for the rain, snow, you name it.
Yeah, but my question is, why build, I mean, that's a very large house on that lot. Why build the house that big? Or, if you push the and I don't know, exactly from, ask staff, how much smaller would the house needed to have been? Could you have pushed made it, 3 feet shallower? Would that have allowed the two-car garage?
I mean, it's not a problem that we cannot fit the two-car garage on the lot. The problem is that we are slightly off for the percentage of the
lot
range.
Coverage.
Yes.
And
So the house is not big. It's a standard house. It's a 3 bedrooms, 2 bath on the second floor, and the bedrooms are not large. I did, 2,000 houses in my life like this, and this is, for me, is a less than average house, meaning the size, and I do city lots, so 25 by 125 for me is a typical lot. It's not, I do understand for Evanston it's a smaller lot, but for Chicago we do even do 24 by 100, and I was shocked that I cannot do the two-car garage.
But my question is, was this, the back and forth with the discussions with the city, did they not explain the lot coverage requirements?
I can. Commissioner Lindwall, I actually was the staff person that did that review, and I did in fact explain that they needed to reduce the lot coverage. It was a suggestion that if they wanted to keep the house with the same footprint, that they do a one-car garage or no garage, to keep the house footprint as it was proposed. Originally, when I first reviewed this, given this is a substandard lot in Evanston, it did trigger, I think, more than 12 variations in my first review. They did eventually propose what the permit was issued for earlier this year with the single-family home and parking pad. So they have, had permission to construct the single-family home. It was the accessory structure permit for the two-car detached garage, where the same building lot coverage and pervious surface lot coverage issues were brought up. And so they're here this evening. They were granted side yard setback variations through the minor variation process last year. And so we were able to get the 3 1/4 setbacks on the north and south lot lines. So that was the back and forth. I can say if I misguided you and that you had to have a one-car garage or no garage, that was certainly not the intent of the review comments. But it was ultimately their decision to proceed with the house as it's presented tonight, triggering the variations.
Any other questions, Commissioner Lindvall? No, okay. Did you want to add something, sir?
I was just, if Mr. O'Byrne may be able to provide a little bit different input to your question, if you would like that. Okay, and he's a real estate broker, and this would be a feasibility of the building process and developing single-family property.
Hello, Council. Speaking to the house and the design of it, I was not party to the conversations
within the zoning or architectural approval process, but the home is designed with an intent to meet the needs of modern buyers. The layout, floor plan, sort of square footage that buyers are looking for, not to build a larger than average house, but sort of to meet a minimum standard of what buyers are looking for. With regards,
Excuse me, what is the square footage of the house?
the house is 58 feet long, I believe, there by 19, so it's about just under 2,400 square feet above grade, 20 in the 2,200.
58 by 19 times 2?
Yeah, I can just do that for you real quick.
It's 15 and a half feet long by 18 and a half feet in width.
No, not the
Oh,
garage, the
oh,
house.
sorry.
So we've got 58.5 times 18.5, so 1,082 per floor, so 2,165 feet above grade. With regard to the garage, just doing a quick market study, I looked at new construction homes over the last decade or so, found 95 examples. 94 of them were built with two-car garages. The one exception was a home built by a program called Live Evanston, was an affordable housing design built with without a two-car garage. The owners have since put up a two-car garage. So the overwhelming evidence is that this is what is not only feasible to a builder or marketable, but also an expectation or requirement of owners. So I think the reality here is, buyers are expecting this, will have two cars and the need to utilize two-car parking. So, we're not simply looking at this through the eyes of profitability, but through the eyes of the community members hoping to move into the Evanston area.
So I have a couple of questions for you.
Sure.
You throw out some numbers about houses and two-car garages. How many of those were on substandard lots?
I don't have that information.
And then when were you brought into the project? Were you brought in to advise at the beginning of the project or recently?
I did minimal advising on the beginning of the project, not from a architectural directing standpoint, but maybe for a review or commentary position.
And did you recommend to the homeowner at that time that a two-car garage would be necessary?
Certain. To me, that is a requirement of modern homes, yes.
And did they ever tell you that they were going to go with a parking pad or a one-car garage?
I'm aware of that. I cannot recall at what point in the process I was aware of that. Certainly the expectation from the beginning was this was what is needed to successfully build and sell a home in this market.
And what would you say, since you are a real estate broker, would be the average sale price for a home like this?
Oh,
I don't need
wow.
an exact dollar amount, but I need a
Well,
range.
it's a number that's falling currently, but I think we were probably in the $800,000 to $900,000 range as an expectation. We're seeing significant price drops over the last, I would say, 4 months, and probably expected for the foreseeable 6 months. So when the project finishes and where the market lies at that point is a little bit unknown.
Yeah, I can't expect you to know that at that time, yeah. Okay. Any other questions? Commissioner Mironchev?
I don't know whether I have to address my question to you, but do you think that with your architect, you checked all the checkpoints that could be beneficial to comply with the two requirements for impervious surface and for building coverage? Because once again, it's relatively small. It's something like 2% in both cases. So for impervious surface, there are very easy solutions like stepping stones or reducing the walkways. For the building and garage, though, it's a little bit more difficult, but still there are architectural tricks that probably could have been applied here. Are you familiar with this? Do you have any conversations with the architect? And were all the options actually tried?
Yes, that will be a question to me. Yeah, we did whatever we can so all the sidewalks are done with the pavers. We have everything concrete before. The same, the patio back on the rear of the property used to be concrete. I'm sorry?
I will interrupt.
Sure.
How wide are your sidewalks?
They are roughly 3 feet.
can you use 2 feet 6 inches?
Yes, I could, but
So I'm just giving an example of something like a architectural trick. I'm running into this all the time, but ordinance is an ordinance. So you can replace this with stepping stones. You can reduce it to 2 feet 6 inches, which will be probably okay, and you will eliminate one of the requests for minor variance, the impervious surface. Probably this will be okay with the 2% that you need to kind of give up.
so I believe the real plans, the approved plans are a little bit different because this is what we apply for. So if you somebody can move this down, maybe down the screen, because this is a 2-car garage right now. This is what I believe.
It is correct that the permit issued for the single-family home and the parking pad did approve the 3-foot wide walks.
And additional question probably to staff, is the front porch considered part of the building coverage?
It was applied, the 50% deduction that is allowed for front porches was applied. So it did have a reduced lot coverage from the building lot
So
coverage requirement.
do you want to trade the front porch for the garage?
I mean, we still need the entry to the house, right? So we need the stairs.
Well, once again, I am asking typical architectural tricky questions because you have to comply with an ordinance, and you are not complying, and there are still things that probably could be done so that you can comply. I'm trying to help.
Yes, of course, and thank you so much. I mean, we need some kind of porch, but if you're telling me that if we're gonna cut the most of the porch, we're gonna keep the stairs and the landing, right? If we're gonna cut off the rest, if you're telling me that's gonna get me the 2-car garage, that would something I would obviously consider.
I cannot state it immediately, but just looking at the percentage that you have to comply, probably. It's your architect that have to make the calculations.
That's, I believe the porch, Walter, is a covered porch?
It's covered porch, yeah. So the porch is already almost done, so roof on the porch is done, we're only looking to build the deck. So at this point, nothing could be done. My question would be, if we're gonna, because all the pavers are permeable, okay? So if we're gonna get a smaller percentage of this, that's gonna give us a coverage?
Once
Because
again, I'm not calculating at the moment, I'm
if they're
just
already-
asking.
But if the paver's already permeable, okay, so that should be like, I just don't understand how they calculate it, So if we can, how the pavers are calculated, permeable?
Permeable pavers receive a 25% deduction. So, for example, if you have 100 square feet of permeable pavers, they would be counted as 75 square feet toward your total impervious surface lot coverage. From what I recall, permeable pavers or stepping stones were suggested to you to continue to reduce and comply with the impervious surface lot coverage requirement.
By the reducing amount of the pavers, we can maybe achieve the, basically this 2-car garage, right?
Perhaps we would need to do another
Calculation?
analysis. I would say, though, that the parking pad was compliant because I think you had permeable pavers for the parking pad. The garage, it counts as 100 square feet equals 100 square feet. So that might be what also is tipping you over with the impervious surface lot coverage.
Okay. Yeah, what we're really asking is just small, basically percentage, like this minor variation, So we can also work with the amount of the pavers to try and achieve, maybe some compromise somehow to.
Any other commissioners have questions?
Yeah, any other questions, maybe?
Hearing none, you can go ahead and have a seat if you'd like. Ms. Klotz, you were the zoning administrator who made this determination, is that correct? Since you are the zoning administrator. but sometimes we pass duties around. Is there anything you would like to add into the discussion?
Just to clarify that, there were discussions by multiple staff, myself included, with the applicant back at the time of the plans for the house prior to construction, and extensive discussion about whether the house should be shrunk to achieve the garage, et cetera. And it was made quite clear to the applicant that if they were to max out building lot coverage and impervious for the house, then a variation to later add a garage would not be appropriate since it is a self-created hardship.
Thank you. Is there anybody else who wishes to speak? I don't see anybody else in the room. So I'll ask if the applicant has, or the appellant has anything they would like to add before we begin our deliberation.
No.
All right, thank you. With that, I will close the record so that we can begin our deliberation. Again, this is an appeal of the zoning administrator, but when we hear an appeal, we review a case as if it is coming to us for the first time. And therefore, we can take into account facts that other factors on the property other than the specific appeal that is before us. General thoughts from commissioners?
This is a perfect example of why we have the process that we have. And it's clear that the applicant was told maybe numerous times by the staff how they could comply with the zoning code. And in my opinion, the applicant disregarded those conversations by staff and did what they wanted to do. I don't think that's, knowingly going against the zoning code is not cool.
Thank you, Commissioner Halleck. Other thoughts from other commissioners?
I agree with Commissioner Halleck. I think that, that's it.
All right. I will not prolong this any longer. I think I get a general sense for the commission. I will just say that, I think it would be very different if we were hearing the entire project as one. But since we have already had the majority of the project completed and are now being asked to grant an exemption or a variation because of a condition that's been created because half the project is already done, is a little problematic for me. The fact is that this is a substandard lot. We often have substandard lots in Evanston, and they are often built upon successfully, but they often are not built with a 2,100 square foot home. And if that is what the applicant desires, then there have to be trade-offs. And unfortunately, we are left now with not really having anything to trade off. And we aren't going to sit here and be able to negotiate the impervious surface because we don't have the numbers in front of us. And so for us, that's not fair. It's not fair to you to do that as well. We do have a set of 5 standards that are standards for minor variations that we must find are met. Again, we are the determining body in this particular case. So we will go through these standards, and as soon as I wake up my computer, just a moment. So the standards for approval for a minor variation, the first one being the practical difficulty is not self-created. This is where I have the greatest problem because, again, we are being asked to grant a variation based on the fact that a majority of the project is already done and completed. If this had been a project that had come to us with a 2-car garage and a house, we could have looked at how do we trade off to get things closer to the impervious lot coverage as well as the building lot coverage. So I don't believe that this standard, I believe this standard is not met. Number 2, the requested variation will not have a substantial adverse impact on the use, enjoyment, or property values of adjoining properties. Again, a number of these properties do have 2-car garages. along the area, which does help alleviate some of the congestion on the street. We also see some properties on this lot which have no, or I'm sorry, properties on this alley which have no garages. And some of the ones that we've shown that are larger are also on larger parcels of land. But I'm willing to grant that obviously being able to remove 2 cars from the street does have an impact that would be an improvement for the neighborhood. So I'm willing to grant that this standard is met. Number 3, the requested variation is in keeping with the comprehensive general plan and the zoning ordinance. Obviously, we often seek to have on-site parking. We also seek to have new construction where old construction is deteriorated to the point that it is about to fall down. And we are grateful when developers take those properties and are willing to redevelop them. The issue that, again, I think comes into play in this one is that it really is a maximization of the building itself that creates this problem. We have 25-foot lots which are developed regularly. We've even actually increased some of the setbacks so that they can be developed more easily. So I think that this particular one, the standard just is not met. The requested variation is consistent with the preservation policies set forth in the comprehensive general plan. There's nothing here at play in terms of the preservation, so that standard really is non-applicable. And number 5, the requested variation requires the least deviation from the applicable regulation among the feasible options identified before the zoning administrator, or in this case, the land use commission. And again, this is a situation where our hands are kind of tied because the applicant or the appellant moved forward with the majority of the project and then has come to us and asked us to approve the last little bit of it. And so I think that this standard is not met. Is everyone in agreement with my finding on standards? With that, it is typically our practice to make a motion for approval as opposed to making a motion to deny because of the fact that that way everyone's a little more clear on exactly what they're voting on. So yes would mean yes to grant it, no would mean no to deny it. Therefore, I'll ask if there is a motion for approval of this particular project located at 20, I've lost the address, 2012
Maple.
Maple.
Just a point of clarification, is this one where we need to have 6
Yes, we
votes
do
one
need,
way
since we are determining body, we do need to have 6 concurring
votes,
votes.
one way or the other?
Yes.
Okay. With that, I move granting the appeal of the zoning administrator's decision to deny minor zoning relief for 2012 Maple Avenue, case 22 ZMJV-0075.
Is there a second?
I will second.
It's been moved by Lindwald and seconded by Westerberg. Is there any further discussion? Hearing none, would you please call the roll? Yep.
Maybe I just didn't understand your motion.
The motion is to grant the appeal.
So a yes would mean yes, and a no would mean no. We do it that way so that there's not confusion, so you aren't, yeah, so that you aren't
Yes.
granting yes to say no, and vice
Yes.
versa. All right.
All right. Commissioner Halleck? Commissioner Hugo?
No.
Commissioner Johnson? Commissioner Lindwall?
No?
Commissioner Miranchev?
No.
Commissioner Pucktall?
No.
Commissioner Westerberg?
No.
Chair Rogers?
No. So with a vote of 0 in favor and 8 against, the motion fails and the project is not granted. You can work with city staff to figure out, again, we've talked about some of the options that are available. And so talking to city staff about, where you might be able to gain some square footage and things like that.
Understood, thank you.
Thank you. With that, we will move on to just kind of our business keeping ends of our agenda. The first one is any communications that we need to be made aware of?
I am not aware of any unless the commission would like to hear what is planned for the November 9th meeting.
Yeah, yes. we would.
All right, so we will have a meeting on Wednesday, November 9th, 1453 Maple Avenue. It's parking variation to allow apartments at the Masonic Temple. It's being adaptively reused for residential. 1603 Orrington Avenue, a major variations for 3 signs on the office building in the downtown. And 321 Howard Street, the special use for a convenience store that was continued from the October 12th meeting of the Land Use Commission. We are aware that this is the first time this body will be reviewing major variations for signs. If you have any questions about how that process may work, we're happy to kind of try to update you at this meeting, and we'll do our best to explain that in the staff report. And that case is being managed by zoning administrator Melissa Klotz.
Actually, when you said November 9th, I was thinking November 30th or whenever the,
Yeah, we'll have a special.
can I ask a question about that?
Sure, that, we did do, I guess, a quorum check to schedule a special meeting on November 30th. There has been an application filed for a special use for a rooming house at 1566 Oak for the Margarita Inn, and Melissa Klotz is the case lead for that.
Okay, I just wondered if I should bring my sleeping bag. So my question is, do you know whether the community group is satisfied with the proposed standards?
I'll defer to my colleague, Melissa.
I believe those discussions are still ongoing.
Still ongoing, okay.
And then we don't meet, so we're going to meet November 9th and then November 30th. We don't meet the night before Thanksgiving, I trust.
Correct. I believe that date was excluded from your calendar when you adopted your dates.
Yes. I'll just say that we have a lot of very big cases coming our way, so attendance is important since we still are required at present to have 6 members voting affirmatively for anything on which we are a determining body. So please try to attend if at all possible. I don't see any public left to comment. So I will ask if there is a motion to adjourn until our meeting on November 9th.
Motion to adjourn.
Moved by Lindwall. Is there a second? Second by Westerberg. All in favor, please say aye.
Aye.
Aye, thank you. And we do stand adjourned until November 2nd, 2022 in council chambers at 7 o'clock. Thank you.